Good evening, everyone. It is my pleasure to welcome you to this joint event organized by the Ukrainian Arbitration Association together with Swiss Arbitration Association. We have today a very interesting topic, which is in one way not directly related to arbitration, but another way it's very related to enforcement, recognition, enforcement, which the issues are very similar both for court judgments and arbitral awards. And today we will be discussing the recognition enforcement of Ukrainian court judgment in Switzerland. So from the side of Swiss Arbitration Association, we have board member Christian Oettinger. He will present the speakers and the Swiss Arbitration Association.
Yes, hello everybody. On behalf of the board of ASA, the Swiss Arbitration Association, I also warmly welcome you to this webinar. We are very happy to join forces here with the Ukrainian Arbitration Association. And I would like to thank Olena Perepelinska, Alexander Truk, who you have already heard, and Alexei Maslov for their support in organizing this webinar. At our end, I would like to thank ASA board member Urs Weber-Stechel for the initiative, Dieter Hoffmann for the organization at our end, and Sandrine Giroux for joining us today. And Alexander, if that's okay, I would leave it to you to briefly present the speakers.
Of course, sure. It will be my pleasure. So today we have three distinguished speakers. They are all Swiss lawyers. And first is Sandrine Giroux. She is a partner at Laliv, specializing in domestic international litigation with focus on commercial financial disputes, fraud, asset recovery, white-collar crime, mutual legal assistance in civil and criminal matters, as well as international sanctions. Sandrine regularly advises, represents companies and individuals in the recovery and protection of their assets for provisional measures, freezing orders, recognition enforcement of foreign judgments and awards, cross-border insolvency proceedings, and execution of contracts. Our next speaker is Dr. Christian Oettinger. He is managing partner at Vischer, specializing in litigation and arbitration. He represents companies in proceedings before state courts throughout Switzerland, as well as domestic foreign arbitral tribunals. He also sits as an arbitrator. Christian also supports the parties to foreign court proceedings in matter of mutual legal assistance. And as we already heard, Christian is a member of the board of the Swiss Arbitration Association. And our third speaker is Dieter Hoffmann, who heads the litigation arbitration team at Walder Wyss. His primary focus is dispute resolution in complex, mainly international cases, ranging from pre-litigation advice, representation of clients in courts, and arbitration proceedings, coordination in cases involving multiple jurisdictions, enforcement of foreign judgments and arbitral awards, and international legal assistance. He also sits as an arbitrator in international arbitrations. So these are the speakers for today's discussion. And what we thought today, together with speakers, is that we present a case where a Ukrainian company claimant who received a judgment from Ukrainian court against Russia comes to a panel of Swiss lawyers. And we discuss different aspects, what would happen, and is it possible, and what are the issues that a claimant with Ukrainian court judgment may face in Switzerland. So maybe a couple of words about the judgment. As our listeners are probably aware, last year there was a precedent of the Supreme Court of Ukraine, where the Supreme Court said that in cases relating to torts for damages caused by Russian aggression, Russia as a state does not enjoy sovereign immunity in Ukrainian courts. This led to a series of various claims in Ukrainian courts where the claimants received judgments against Russia to recover their damages. These judgments were obtained in civil and commercial proceedings, both by companies and individuals. And obviously, there are issues with this judgment because the respondent in the proceedings, Russian Federation, does not participate. So these are mostly judgments of the courts of first instance. Secondly, there is a big issue with service of process because currently there are no diplomatic ties between Ukraine and Russia, so it's not possible to serve the proceedings through diplomatic channels. And there is equally no postal connection or possibility to deliver documents by courier service. Some of the claimants in Ukrainian proceedings try to circumvent this by serving Russia through diplomatic embassies in third countries like Poland or Kazakhstan or Baltic states. And Ukrainian courts at the end published the announcement on the participation in the court proceedings to the respondents through official website of the court administration. There are quite a lot of these cases already, and Ukrainian claimants are exploring whether it's possible to actually enforce on these judgments and obtain certain award to enforce on their claims. And this is where we come to Switzerland as one of the jurisdictions where Russian assets may potentially be located. I think what we discuss with the speakers, we will first have a short PowerPoint presentation where we go through the recognition enforcement process in Switzerland. And then we'll have a specific question dealing with various aspects of the recognition enforcement. So for the presentation, let me share the screen. And please tell me when you see the slides.
Now the slides are on.
Great.
Well, many thanks. The warm welcome from my side. Sorry?
Yeah, please go ahead.
Have you finished, Alexander? Well, a warm welcome from my side. Before we actually start with the presentation, Sandrine will do that in a minute. Just on behalf of all the three speakers, we wanted to make a caveat at the beginning. Some issues and some topics that we are going to discuss are rather complex, and not all of them are settled law. So there are issues that are still under dispute and disputed. So that just needs to be borne in mind with a view to the subsequent presentation and discussion, that there are certain aspects that are not yet settled. That is just a general caveat. And now I would be happy for you, Sandrine, to start.
Thank you very much, Dieter, and thanks again, Alexander and your team, for inviting us to discuss this important topic. So I'll start with a general overview of the recognition and enforcement legal framework in Switzerland, because it's important before we go into the detail and try to be creative to see how we can bend the rules in light of the unprecedented situation we're facing, to understand really what are the basic rules. So the first point is that there are no bilateral treaties between Switzerland or Russia or Ukraine regarding recognition and enforcement of judgment. There is I think you went back, Alexander, if you can just go back to slide 2. Right. Switzerland is a member of the Lugano Convention community, so that facilitates enforcement, but Ukraine and Russia are not part of it. It's essentially an agreement between Switzerland and the EU. If you could just go back one slide, Alexander. Thank you. So by default, what applies is the Private International Law Act, which we call PILA, which sets out the basic rules for recognition and enforcement of foreign judgment in Switzerland. If you can move to next slide, please. The main provision is Article 25 of the PILA, which states that a foreign decision is recognized if, number one, the authority which issues the judgment had jurisdiction, that the decision rendered is final, and that there is no ground for refusal. which is Article 27, which we'll examine in a minute. As for condition 1, the jurisdiction has to be established based on the jurisdiction rules set out in the pillar. So you need to have indirect jurisdiction as set out in the pillar. So jurisdiction of the Ukrainian courts based on Ukrainian law may not be sufficient. Switzerland and Swiss law and the pillar must establish an indirect jurisdiction basis in order for the foreign judgment to be recognized. And that's one of the tricky bits to keep in mind. Now, moving on to next slide. Here are the grounds for refusal. These are quite, I would say, standard. They reflect most of the international conventions on enforcement. The main reasons for refusing recognition and enforcement is the manifest incompatibility with Swiss public policy. Paragraph 2 sets out further rules. The defendant has to be duly summoned of the proceedings, and the summon needs to happen according to the law of the domicile of the defendants or its habitual residence. Here we're talking about general rules. When it comes to state, is a bit different. There are obviously different process, and we'll discuss that later when we come to the discussion on the case study. But as a general rule, it has to happen according to the law of the defendant. Another requirement is that there is no violation of principal procedural law, in particular the right to be heard. Another grounds for refusal is if there has been res judicata already, and another decision can be enforced in Switzerland, which is competing with the second decision. So these are basically standard objection grounds that you find in other conventions, such as the Lugano Convention. There is another rule for judgment rendered by default, which in which case you have to prove that the defaulting party was given proper notice and had the opportunity to present its defense. So all in all, that's the overall legal framework for recognition and enforcement. Now, when you have a judgment which can be recognized and enforced in Switzerland, you still have to proceed by way of certain procedural rules, and that's next slide, please. In Switzerland, we distinguish between monetary claims and non-monetary claims. Monetary claims are claims where you are asking someone for money. So you have a judgment ordering the payment of an amount, that's a monetary claim. If you're asking someone not to do something or to do something, for instance, if you're asking a bank not to transfer money, or if you're prohibiting, let's say, a service provider holding a painting not to transfer the painting, and it's relevant in the context we're talking about because there are also sometimes artworks which could be targeted in the enforcement process. Well, these type of requests are non-monetary claims, and the enforcement process is different. For everything which is monetary claims, it is enforced under the Debt Collection and Bankruptcy Act, which provides limited grounds for provisional measures, the main one being the attachment, and we'll come to that in more details later on. When it comes to non-monetary claims, the applicable rules are those set out in the Swiss Code of Civil Procedure. And there you also have different sets of interim measures. And that's very important to keep in mind, because sometimes you may have a nice order, but you don't know how to enforce it. That happens, for instance, when you have an English freezing order, which is an ad personam measure in relation to an amount to be paid. then it is often very tricky to enforce it in Switzerland because the attachment provided under the Debt Collection and Bankruptcy Act, it only targets the assets and not the person. So normally you would have to go through the interim measures because you're asking a bank, for instance, not to give any money or to block the money of someone up to a certain amount, but you're targeting a person. So it's probably a bit technical as an example, but just to show that because of these dual systems, sometimes it is difficult to import a foreign decision into our system. And it is very important from the outset, before you get the judgment, to think about what you want to have, because you may be able to have a different order in your judgment, which may ease the enforcement process. Now, if we can move on to next slide.
Sandrine, if I may stop you
Yeah.
here, I would take over if that's fine with you. Okay. Well, you have actually already covered more than anyway. We are where we are. I'm happy, as set out by Sandrine, it's very important to make this distinction between money claims and non-money claims. We thought that based on the case scenario, we will mainly be discussing money claims here, a judgment for a certain amount of money. And that would usually, and you still, as set out by Sandrine, if you want to enforce a foreign judgment here from a Ukrainian court in Switzerland, you still need to apply to the court. And that you would normally combine at the outset with a freezing order. As already explained by Sandrine, you have two options. If you could go back to slide number 6, yes, that's the correct slide. You still have two options, basically. You can either just request the court to declare a foreign judgment enforceable in Switzerland, that you could do, but in most cases, because it's nice to have an enforceable judgment, but most creditors wish to turn it into money anyway. And this is why in most cases, we would start a typical enforcement of a money judgment with a request or an application for a freezing order. You can also call it attachment. In German, it's called Arrest. This is an ex parte decision by the competent court. And in order to get such freezing order, you need to show on a prima facie basis, and prima facie basis in this case simply means there must be more that mere allegations and an affidavit or the like would not necessarily do the trick either. You need clear and detailed allegations that set out the conditions. I'm going to discuss them in a minute, but you also need some objective proof. So for example, if you say that the debtor has a bank account in Switzerland, then you would need to show some proof for that, third-party documents, ideally an extract or excerpt or an account statement from that bank. That would be the ideal case. In most cases, you would not have that, but you need to show some proof or at least some hints that establish the conditions that are there for a freezing order. So simply alleging would not be enough. And going back now to the case of the enforcement of a foreign judgment, well, a main condition is that you need to establish a claim. That would be quite easy. You have the judgment that would basically grant you, for example, a certain amount of money against the debtor, then that condition would already be fulfilled. Then you need to establish a ground for a freezing order. That is also quite simple here. You would need to show that you have a judgment. That is easy, but you will need to show that the judgment actually qualifies for recognition and enforcement in Switzerland, so that all those conditions that Sandrine mentioned earlier are met. And that you would also need to show on a prima facie basis in this part of the proceedings. And then lastly, you would also need to show that there are assets that belong to the debtor and that these assets are in Switzerland and can actually be attached, so there are no issues with state immunity, etc. We are getting to that in a minute. So to cut the long story
Dieter, maybe
short,
just a
sorry?
quick question at this point.
Yes.
Quick question at this point. How specifically you need to
Now I had a difficulty hearing you. Sorry, if my line was bad. Could you come again?
how specifically a claimant would need to identify the assets? Can a claimant generally say there is real estate, or the claimant needs to specifically say which exact real estate?
Thanks, I've now heard you. Sorry for the bad connection. No, you would need to state that specifically. You would need to show, for example, that the debtor has a bank account with a specific bank. So you cannot just go out and freeze any and all assets with any and all banks in Switzerland. You need to show that the debtor has an account with a bank. You would not necessarily need to have the account number, etc., but you would need to establish the bank. And when it comes to real estate, there you would also need to say what property that is. Here, actually, it can be easy when you have the address. Then you can check the local land registry, because it's very easy to get information who actually is the owner of a property, but you would not necessarily get more access. But you could, for example, if you know at a certain street, building number 1, then you could check with the land registry without without proving anything that you have a justifiable interest. You could just request the information to whom that property belongs, and that would then basically be sufficient. And that is nowadays even more easy than it used to be a few years ago, because now in most parts in Switzerland you actually could actually check via the internet. But you can only check regarding a specific address. You could not do, for example, check for example, how many properties are owned by Christian Oettinger. That would not work. You can only go after specific properties. Has that answered your question? Okay, good. Yes. So basically, that's what we wanted to say regarding the freezing order. That normally would open enforcement proceedings. And why is that? Because in most cases, when you have a money judgment, you would really like to freeze the assets so that you not have to go after the assets. And this is why it is a very good idea usually to get this freezing order at the outset. Then the assets are frozen, whilst the enforcement takes some time, and you go through the enforcement process, which actually means that you get the judgment that you have shown qualifies for recognition enforcement on a prima facie basis. That is then tested later on in court proceedings. And now I would hand over to Christian, I believe, unless, Alexander, you have further questions at this point.
No further question at this point. We'll have some questions later.
Great. Christian?
Yes, would you go just on one slide? Yes, so the first topic I want to address is the statute of limitations with regard to claims confirmed by court judgments. Now, under Swiss law, a claim confirmed by court judgment is time barred after 10 years. You see Article 137 of the Swiss Code Obligations on the slide. And the limitation period can be interrupted. So there are certain steps you can take to do so. And in this case, in case of such an interruption, a new limitation period of 10 years starts to run. So that's the situation in Switzerland. Now, with regard to foreign judgments, or rather claims confirmed by a foreign judgment, the Swiss Federal Supreme Court has decided that Swiss law is not applicable with regard to the statute of limitations. Rather, in the decision, I put down there 148 Roman 3 420. The Swiss Federal Supreme Court has confirmed that the law of the state where the judgment was rendered applies. So in the case of a Ukrainian state court judgment, Ukrainian law is decisive for the question what statute of limitations applies to the claim asserted by the state court. So I think this is important to understand. So if this issue comes up, it will be Ukrainian law that governs the question. If we go on, Alexander. The next topic then is state immunity. Sandrine and Dieter have already alluded to that. So while Switzerland recognizes state immunity, there are no statutory rules that deal specifically with the issue in general. At the end of the day, the rules on state immunity under Swiss law are based on case law, and this means that there is a certain degree of flexibility. State immunity is based on the principle par in parem not habet jurisdictionem, or put otherwise, equals have no sovereignty over each other. The Swiss Federal Supreme Court applies the principle of restrictive, not absolute immunity. This means that Swiss law distinguishes between acta iuri imperi and acta iuri gestionis. The state immunity does not apply to states only, but also to state agencies. That's also an important point to have in mind. Now, the state immunity is relevant with regard to the Swiss court's jurisdiction and at the enforcement stage. And if we can go to the next slide. What I've just said leads to the chart you can see now on the screen. Both with regard to jurisdiction and enforcement, acta iuri gestionis are not, or at least not generally, covered by state immunity. And when we look at enforcement, there are three requirements that must be given. First, the legal relationship, which is the basis of the enforcement, must fall in the category de iure gestionis. This requirement relates to the nature and not the purpose of the transaction. Second, there must be a sufficient relationship to Switzerland. This is given A, if the legal relationship came into existence in Switzerland, B, if the obligations under the legal relationship had to be performed in Switzerland, or C, if the foreign state has taken actions in Switzerland that are sufficient to create a place of performance here. We will see later on that this requirement of a sufficient relationship to Switzerland actually creates quite a burden in relation to enforcement in a lot of cases. And then third, pursuant to Article 92, paragraph 1, section 11 of the Swiss Debt Enforcement Act, the garnishment of assets of a foreign state or a foreign central bank which serve sovereign purposes is not possible. In other words, enforcement is only possible if there are assets in Switzerland that fall in the category de iure gestionis. So that's what I wanted to say at this stage on immunity, and I think we come back to the issue when we deal further with this scenario.
Great, many thanks. So now that we know the general framework of the recognition and enforcement of foreign judgments in Switzerland, we can come back to the case study that we have, a Ukrainian judgment, where Ukrainian claimant obtained a judgment against Russian Federation for damages caused by Russia due to its attack on Ukraine. And we will probably go question by question and looking into different practical aspects, what would happen in the course of recognition enforcement of the judgment in Switzerland. So first question is to Sandrine. The question is, why do we even come to Switzerland? Is it a good place to enforce, and other assets available for enforcement?
Thanks. Well, Switzerland is certainly a good place to start. Is it an easy place to enforce? Then the answer may be different. As you all know, Switzerland is one of the most important private wealth centers in the world. There are a lot of banking assets, but there are also a lot of companies with shares, holding companies. There are also a lot of luxury goods, be it chalets or artworks held in free ports. So it is really a place where you have a lot of wealth or assets to trace and attach. Now, the general enforcement process is quite difficult, as per the rules that we presented and the explanation mentioned by Dieter. You can see that the process is quite procedural. So you have still to establish a few things before you can get to a positive outcome. And generally, Switzerland is very defendant friendly when it comes to enforcement. It is very difficult to enforce because it is difficult first to locate the assets. They are, well, generally banking secrecy. There is no discovery process. So generally, it's very difficult to reascertain specifically what the assets are and to whom they belong. There are other issues such as lifting of the corporate veil, which is quite difficult to establish. So procedurally, for defendant, you have many options to try to delay or prevent the enforcement process. Now, when it comes specifically to Russia, there were a lot of Russian assets or interests in Switzerland because there were many ties. As of recently, the assets, there was approximately 7.5 billion Swiss francs of assets frozen under sanctions in Switzerland. That doesn't reflect the whole of Russian assets, but obviously you can't go after any Russian asset. It has to be linked either to Russia as a state, and the 7.5 billion is only a fraction of the overall amount of Russian interest in Switzerland. But as per the recent statistics, which give an overview of what could be tied to the state, there were 7.5 billion, as I mentioned, and 15 properties, so quite important properties of several dozens millions. But there are also artworks held in free ports. There was just 3 days ago an article in the Swiss press about assets which were frozen in the in the Geneva free port. So these are all assets under sanction. It doesn't mean that now you can target them easily with a civil judgment, but at least you know that there are some things to look for. And I think that's what I wanted to say generally of why seeking enforcement in Switzerland. Yes, there are assets, but it's probably one of also of the most difficult places to enforce in comparison to other places.
Many thanks, Sandrine. It's good to understand it. And Dieter, you mentioned previously that you usually start the enforcement by receiving this attachment. How would this apply in case of enforcement against a sovereign state like Russia?
Now, here you would also need to first establish that you have assets, and you would also need to establish that in spite of state immunity as set out by Christian, and he's happy to go into more detail there, that you actually have assets that you can freeze. Now, on the level of a freezing order initially, where you basically just need to establish on a prima facie basis, if you come up with a really good story that a certain asset is not protected by the rules of state immunity, then you might have a chance, and then at least it's blocked. I mean, right now here, the special situation is that quite a few of those assets that might actually be interesting for enforcement, not all of them, as explained by Sandrine, but quite a few of them will be blocked by the sanctions anyway. So that is a special situation. But yes, you would normally start with a freezing order, but here it's really tricky because you would need to establish you always have the issue that it's not so easy to exactly say where assets are. And for example, I mean, the embassy, the embassy obviously is property, but I mean that would not be freezable. That is clear. So you would really need to show all these conditions on a ex parte level. But the tricky issue here is really that you find suitable assets. So the first hindrance or hurdle is that you need to show where these assets are, but then you would also need to establish that they are actually freezable, that you can enforce against them, hence that you do not have an issue with immunity. And that will be the tricky bit.
Just to follow up, Dieter, in this case, would it be necessary to show that this is a commercial asset and not used for public purposes, or what would be the test for freezing the asset?
Well, on a simple level, yes. Christian can go into that in more detail, but essentially, yes, if you can show that this is just a simple commercial asset, then it would be fairly easy. But mind you, you would still need to establish that you have an enforceable judgment, and there are some issues there as well. But just to give you an example, if you can establish that there's a commercial asset that belongs to Russia as such, and you know where it is, then yes, it would be possible.
Mm-hmm. Another follow-up question. As both you and Sandrine already mentioned, some of the assets are already sanctioned. So as I understand, they are blocked, so it's not possible to do any transactions with them. But could the judgment creditor still get also an attachment on these assets if they are commercial?
Well, my understanding is yes, an attachment would be possible. It's in my book, and Sandrine and Christian can jump in on that as well. In my book, it's similar to if an asset is being blocked by, for example, criminal measures, then you can still get the freezing order, but then it's just frozen and you could not ultimately enforce in it. It's somehow blocked. And for example, a criminal measure would take precedence. So in other words, yes, I believe you could get the freezing order, but you could not get any further, or then you come into the rather tricky waters of what exactly is the importance and relevance of the sanctions.
Mm-hmm. And maybe question to everyone, based on your experience, what is the usual procedural way how to actually search assets? So we heard from Dieter that it's possible to search based on the address of real estate, but in respect of other assets, what are the tools that are usually used to search?
Well, that's a tricky question. I mean, for example, sometimes, if you can establish a bank account because it's mentioned in the contract, or you get access to copies, that is one possibility. Real estate we have discussed. Then there may be shares. You know that there is a company in Switzerland in which the debtor has shares. Then it depends whether these shares are issued in paper form. Then it's more tricky. Nowadays, most of these shares are no longer issued, and then you could basically treat them like ordinary claims and could try to get the freezing order here in Switzerland. But normally, leaving aside the whole issue of enforcement against states, one of the difficult hurdles, Sandrine has explained it. In my book, Switzerland is very generous when it comes to recognizing and enforcing foreign judgment as such. I mean, there is no rule of reciprocity or something like that, but to actually do it is then quite difficult, because you would need to meet all these conditions. But for example, with shares, that's a possibility. Real estate we have discussed, bank account if you have hints. Sometimes there are clients that provide you with reports from private investigators. That can be tricky because if that evidence was obtained by illegal means, for example, bribery, then you cannot really use it. In most cases, you could not use it. But Christian and Sandrine, you might wish to jump in here.
Thanks. Yeah, I fully support what you say. I think especially the last point, it's really important to make sure that the information you get is not tainted. And you need to keep in mind that Swiss banking secrecy in Switzerland is something very serious. If you breach it or you entice someone to breach it, it could be a criminal offense. So that's very important to keep in mind when you source information. Now, when it comes to state, because here we're talking about enforcing a judgment against the state, so you need to find assets of that state, and it's not so easy. They are generally, there's a precedent, and maybe Christian, you'll mention it, with the Pushkin paintings, which were attached a few years ago. There was another creditor of Russia who tried to seize the paintings of the Pushkin Museum, which were exhibited in Switzerland. And obviously these paintings were considered immune because these are cultural goods. So this was not possible to attach them. But one way to source assets of a state is to look for claims, because claims as such are also enforceable. So thinking about, for instance, oil or commodity trading, if you have a commodity trader who has a claim, if Russia has a claim against a commodity trader based in Switzerland, so this trader owes money to Russia, and you can consider that the payment is owed in Switzerland, you could ask to attach that claim in Switzerland. So if you know about contracts between Russia and service providers in Switzerland, then you can try to attach these claims. What is interesting, is that you can also, to a certain extent, attach future claims if you can say they are foreseeable and for a certain period, not too long, generally it's 1 year, but you need to still establish that the claim is due and can be, is foreseeable as well if it's for the future. So you need to have contracts and indicia to demonstrate, at least on the likelihood basis, that such a claim exists. What you generally do is you look for contracts, public information. Sometimes you see also reports from state entities or from ministries about transactions, be it airfare, taxes, or other type of transactions, and there you can identify a service provider and a claim or a balance which is negative, and it owes a debt in favor of Russia. So these are all information that generally investigators, private investigators would look for, which are public information, and then you try to set up your case for a court.
Many thanks. That's very helpful. So going further with our case scenario, so let's assume the claimant has found some asset and even managed to attach it, and we are now launching the proceedings. So Sandrine, what do you think are the main issues will be in this recognition enforcement proceedings in the case scenario?
Well, looking at the conditions we explained from the pillar, two of the very problematic points is the fact that the debtor was probably not duly summoned, and there was the right to be heard was not respected, or that at least two things which will have to be demonstrated. And and I don't want to give too much of what Christian will say, but immunity is a key element in all these analyses. Swiss immunity law is not set in a law. It's based on the case law of the Swiss Federal Supreme Court. There are a few treaties that Switzerland has ratified, but basically when it comes, for instance, to service, and service is also important for the summon. And I know Dieter will go in more detail about that, but generally for service, Switzerland looks at the European Convention on State Immunity and applies it by analogy, because Switzerland has not ratified Switzerland has ratified the UN Convention on Jurisdictional Immunities, of states and their property. But as you know, it's not yet into force. So basically in Switzerland, we will look at the European Convention on State Immunity. And there are rules on service and also by default judgment. And these would be what would have to guide the whole process generally. And so even if you have a passive state or a state which is trying to escape the whole legal process, there are guidelines set out in the European Convention or the UN Convention on how to deal with a state which does not want to enter into the proceedings. So I think it would be extremely important for any Ukrainian judgment to make sure that at minima it complies with these rules, because otherwise it would most likely be unenforceable in Switzerland.
And Dieter, do you have any solutions for the situation that Ukraine faces itself with Russia with no diplomatic ties? So what could be the way to serve Russia?
No, actually, I must say I do not really have a simple mean. I believe this is the biggest problem here, that the service can be effected properly, also because that is generally regarded as very important under Swiss law. So sending emails or the like, that would not be sufficient. And I think we have already heard there are currently no diplomatic ties. So I believe that would be probably the most difficult hurdle here, I believe.
And what is the Swiss approach of Swiss courts if the service was affected not on Russian Ministry of Foreign Affairs, but on Russian embassy in a third state? So, for example, if the Ukrainian court or Ukrainian claimant serves documents on Russian embassy, for example, in Poland, would that be deemed to be proper service?
To be frank, I would be skeptical about that, but I'm not sure whether my co-speakers have a different view on that.
I would completely echo what you say, Dieter, because basically, if you look at the UN Convention on Immunities, it's supposed to reflect customary international to a certain degree. And even there, they established that you have to serve to the Ministry of Foreign Affairs. So I think that Switzerland will not be more creative or more generous in terms of these rules than what customary international provides.
Christian, do you have a view?
No, I just wanted to say that somehow you need to follow the rules, and I don't know how it's in Ukraine, but at least in Switzerland, it's not that you just go to a person and hand him over the documents. I mean, there needs to be some official touch to it. So I think that's another question you need to have in mind, that you cannot just go there as in the American TV movies and just say, you got it now, you're on notice. So there must be some level of formality to the process.
Okay. And Christian, what do you think in terms of sovereign immunity considerations? How the Swiss courts will tackle this enforcement of Ukrainian court judgment against Russia?
Yes, so I mean, the scenario says that the Ukrainian courts basically disregard the Ukrainian law and Russia's state immunity. I think you explained that very well. And you know,
I can actually add the basis for Ukrainian courts to do so. So they also actually refer to the UN Convention on jurisdictional immunity and say they treat it as customary international law, and they base their judgment on the territorial tort exception. So there is an exception in the UN Convention that if a foreign state commits a tort on the territory of another state, then it should not be immune in proceedings relating to that tort. So this is the legal basis that Ukrainian courts are using.
I will come back to something similar. So what I wanted to say first is that on the civil procedure rule in Switzerland, the existence of state immunity leads to a lack of jurisdiction of the Swiss court. So if there is immunity, the Swiss courts do not have jurisdiction. Now, if the Ukrainian courts simply disregard Russia's state immunity, even in cases falling under the Acta Iure Imperii, there may be an argument that Ukrainian courts actually lack jurisdiction from a Swiss point of view. This is what Sandrine referred to as indirect jurisdiction. So from a Swiss point of view, there is a question whether the Ukrainian courts are actually have jurisdiction. My research on this has not revealed cases in which this was an issue, probably because other issues were even more pertinent in those cases. And so there is no clear answer in my view to what extent sovereignty plays a role at this point of the test. But whatever the answer to this question is, it is clear that the Swiss court seized with a request to enforce a Ukrainian judgment will apply the state immunity test I have already explained. And hence, the first requirement is that the legal relationship, which is the basis of the enforcement, must fall in the category of the iure gestionis. Now, this requirement relates, as I explained, to the nature and not the purpose of the transaction. The scenario says that the claims are mostly based on the concept of civil law general tort. And from a Swiss point of view, this is an extra contractual liability. As the tort is committed as part of Russia's war and aggression, it may not be qualified as the iure gestionis under Swiss law. And accordingly, there are at least reasonable doubts whether this first requirement would be fulfilled in the scenario. Then the second requirement is that there must be a sufficient relationship to Switzerland. I have explained the test before. And with regard to the scenario, we can say the following. As the liability is based on a tort committed by Russia in the Ukraine, the legal relationship obviously did not come into existence in Switzerland. Equally, there are no obligations that had to be performed in Switzerland. And finally, Russia has not taken any actions in Switzerland that are sufficient to create what we will call a place of performance here. I understand it's a bit odd to talk with these terms about the situation, but at the end of the day, this means that in the scenario, there will very likely not be a sufficient relationship to Switzerland, which is sufficient. And then the third point concerns the asset against which enforcement is possible. We discussed this already now to some extent. The scenario does not say anything on this issue. However, it's clear that enforcement is only possible if there are assets that fall in the category de iure gestionis. So when we consider the scenario, the overall conclusion is that Swiss rules on state immunity will very likely impede the enforcement of Ukrainian judgments in Switzerland. And this leads to the question whether there are any exceptions. And what I found is that there is a discussion whether a breach of fundamental law, so jus cogens, can be protected by state immunity. I think that goes in the direction that you just mentioned, Alexander. And at least some say that such protection of a state violating jus cogens would lead to a contradiction within the legal system that this cannot be possible. So these people, they argue that state immunity cannot be invoked in case of a breach of jus cogens. But I have to say that this debate is not yet very far advanced in Switzerland, and it's unclear to what extent these arguments might prevail at some stage, and maybe then the others have a view on that. What I also want to mention, though, is that at least what I understand is that the prevailing doctrine and the ICJ have repeatedly emphasized that the granting of immunity is solely a question of the appropriate forum for certain claims against states or enforcement against their assets, but not a question of the violation of the underlying legal violations. So I think this is a distinction which speaks against the application of exception here. But I have to say, yes, I mean, this is an exceptional situation. There may be breaches of jus cogens, and this might be an argument one would like to further investigate.
Many thanks. And I also wanted to inquire with you, Christian, if we don't look at Russia only, but also look at the Russian state-owned companies, because in some of the cases, the majority of the assets are not owned in today's world directly by the states, but they're owned by various corporations, state-owned companies. What is the usual practice of Swiss courts in this regard? And is it possible in the case scenario to somehow try to enforce against those assets?
Mm-hmm. Yes, so in the scenario you explained, we have a Ukrainian state court judgment against the state of Russia. And the question is whether enforcement is possible against assets held by state-owned entities. Now, as a general rule, the enforcement against assets not belonging to the actual debtor itself, here the Russian state, is not possible. And Swiss law in general applies a relatively strict separation between legal subjects, including legal entities. Having said this, it is not impossible to pierce the corporate veil under Swiss law. According to the case law of the Swiss Federal Supreme Court, it is permissible to disregard the legal independence and pierce the corporate veil from one legal entity to the other. Two conditions. If two companies or even natural persons and the company are economically identical. And B, if the invocation of the independence of one or the other legal entity is an abuse of rights. So there are these two conditions. Abuse of rights in Switzerland is always a relatively high burden, I would say. And it's also important to understand that there are two basic scenarios of piercing the corporate veil. First, the assets of the controlling shareholder are liable for the debts of the company, of the subsidiary. And second, the company's assets are liable for the shareholder's debts. Now, in the case dealt with today, the second scenario would be applicable. So the Russian state entities would be liable for liabilities of the state of Russia. As I said, it's not impossible. Piercing the corporate veil remains the exception. The main question is whether the invocation of the independence of one or the other legal entity is an abuse of rights. So whether one can argue that the state of Russia would rely on the separate legal entity abusively. And I have to say this question cannot be answered in the abstract, but the answer very much relies on the facts of the specific case. So it's really a very fact-driven exercise. Yes, overall, this is not an impossible exercise, but usually it's a burdensome one.
Many thanks. And as I see that our time for the webinar is running up, I will have just very short questions to all the speakers to finish up our case discussion. A question to Dieter in terms of Lugano Convention. If the Ukrainian judgment is recognized in Switzerland, does it create any advantages, and is it easier than to enforce it somewhere in other European countries which are parties to Lugano Convention?
Well, thanks, Alexander. No, formally, not on a formal level, because under Lugano Convention, what you actually enforce is always the foreign decision as such, the original decision, and not the declaration of enforceability in another country. So basically, there's no exequatur over an exequatur. But it would, on a material, substantive level, it would normally help if you have achieved recognition and enforceability, declaration of enforceability in another country. So formally, no, unfortunately, that would not help. On a practical level, it might actually help, because then a foreign court might take this into factual consideration.
Mm-hmm. And a quick question to Sandrine. We already touched on the sanction issue and determined that it is possible to have an attachment while the asset is already under sanctions. And what about enforcement? So if we come to already to the stage where we want to enforce and the asset is subject to sanction, will the sanction prevent the enforcement? And is it possible to lift the sanction for the purposes of the enforcement?
Thanks. Well, it's a situation which has not arisen often, so there is no direct case law on this, and generally I would say that it would be the assets will remain frozen as long as the sanctions are in place. There were cases which were a bit similar to that, but then eventually it was in relation to mutual legal assistance it was in support of a recovery of assets from a state, and Switzerland decided to return the assets of that requesting state, and put aside the private claim of a creditor. So we can assume that there would be also such assessment which would be made down the line, but generally the sanction would remain in place and the assets will be frozen until such sanctions are in place.
Thanks a lot, Nadine. And probably a final question to Christian. So we discussed in a case scenario mostly the judgments, but in Ukraine, actually, some of the investors who lost assets, in particular in Crimea, they also filed claims on the bilateral investment treaties against Russia. Some of them already obtained awards, and at least one Ukrainian company announced that they may file a new claim on the Ukraine-Russia BAT due to the loss of assets due to the invasion. So if a claimant has an award as opposed to judgment, would it be any difference in terms of recognition enforcement in Switzerland? You're muted.
Yes and no. So the recognition as such is obviously governed by slightly different rules. But at the end of the day, the issues are the same. In particular, I mean, the New York Convention then governs this question. But then when you come to enforcement, as Sandrine and Dieter explained, you have this, if you have a monetary claim you want to enforce, you end up in the Debt Enforcement and Bankruptcy Act. And there you have exactly the same issues that we were discussing now. So more or less, I would say you can apply what we said today also to arbitral awards.
Many thanks. So I think this concludes our webinar for today. And we actually have managed to comprehensively go through the entire recognition enforcement process. We looked into different aspects where we see issues and how these issues could be tackled. One point maybe from my side as a takeaway, as I understood the approach of the Switzerland or Swiss courts in terms of sovereign immunity is case-based. So it's subject to continuous improvement and evolvement. And there could be new cases appearing, and the courts could look at them with some new approaches. And as we know, the customary international law is also subject to continuous evolution, in particular also on sovereign immunity matters. So from my perspective, at least, I think it's a good starting point to look at this in the timing perspective that not only for today, but for the future development of this sphere. And maybe, Christian, if you have any final words from the Swiss Arbitration Association.
Yeah, I'm not sure if I have the conclusions, or I share the conclusions you made. I don't know if I have others. I mean, only one aspect, I think it was at the IBA in Paris, I heard someone say, Russia does no longer exist for us. I think to some extent we have explained that still like things like service, etc., are very important if you want to enforce a judgment in Switzerland. And I just wonder whether it's not the better approach to actually tackle the enemy and not just denying the existence. I know this is very difficult. I'm speaking here from Switzerland. It's very difficult for you, but I think that's one of the things I learned when preparing this, that you actually need to have an enemy to wrestle with instead of just a no one. And I would like to extend again the thanks to the Ukrainian Arbitration Association and to you, Alexander, for leading this seminar or webinar.
Many thanks again to the speakers, and it was our pleasure to deliver today's webinar to the audience. Thanks
Thank you
again.
very much.
Many
Thank you. Bye-bye.
Thanks.
Bye-bye.
Bye.